This is Sound Education in Succession Law, a podcast where we talk to the experts on the latest succession law topics you need to know about. I'm your host, Susanna Lopez, and in today's episode, we're going to take a look at disclosure obligations of solicitors and trustees and executors in wills and estate matters, and the impact of the court's increased focus on case management in such matters. Joining me on the line is barrister and estate litigation specialist John Armfield from Second Floor Wentworth Chambers in Sydney. John, welcome back to Sound Education. Thanks so much for joining us.
It's very good to be with you. Always nice to speak with you.
Now, first, John, how has the approach of the courts to disclosure in wills and estate matters changed and evolved, you might say, in recent years?
Susanna, the court's approach has radically changed. It has been driven by a number of factors. The first is the cost of litigation. Secondly, the delay, and a feeling that it is important to try and get information to parties sooner rather than later, because if you can get information to people earlier rather than later, you can bring about a resolution of cases quickly, efficiently and justly.
Well, the leading case on the principles applying to the production of information about wills is the New South Wales Supreme Court decision in Re Estates Brooker Payne. What disclosure problems faced by estate litigants were identified by Justice Lindsay in this case, John?
Justice Lindsay looked at the historical approach to litigation. He identified a number of problems that litigants often have. The first problem is to get a copy of the will which is in dispute. The second problem often is to get information as to the circumstances in which a will has been prepared, particularly where it's been prepared by a solicitor. There have been issues about getting the solicitor to prepare an affidavit in circumstances where there wasn't a grant of probate because there was concern in the profession that the solicitor was not authorised to make an affidavit in the absence of all of the persons entitled to the estate agreeing to him or her doing it. Another issue that the judge looked at was the question of getting the solicitor's file, so as parties could look at the steps which were taken to obtain instructions to prepare the will. And finally, the perennial problem of when do you get access to medical records? Get access to them late, which was the tradition, in which case you might spend a lot of money without knowing how strong your case really was, but then it have to be weighed against the risk of getting access to them earlier and allowing witnesses to tailor their evidence.